Hey, welcome back. My name is James Johnson, and my expertise lies in retirement and estate planning. And today we're going to talk about just that. We're going to talk about estate planning and why should you have an estate plan. Well, this is a very, very important subject, and I hope you get a lot from this today because this is something that most people make the mistake on, and they procrastinate. And I can tell you the number one mistake that people make when it comes to retirement and their estate planning is procrastination. So hopefully this will get you up and to get you moving. So once again, I've been in this business for about 19 years now. I'm top of the table. I was a master lead advisor for Ed Slott, ex-Marine father too, president of Rotary, and my expertise lies in retirement and estate planning. Now, SmartMoney magazine, the Wall Street Journal magazine, said that if you have some assets, maybe just a car and some nice furniture or minor children, you still need an estate plan, even if taxes are not an issue. Now, why is that so true? Because see, most people think, well, I don't need a trust. I don't need all these documents because I'm not subject to estate taxes. It's a $25 million exemption. I'm not going to be subject to it. Well, the reality is that what a trust does for you, it keeps you out of probate and death and conservatorship in life, as I'm going to explain to you going forward, regardless of what your net worth is. 56% of Americans don't have an estate planning document in place. 23% of American adults over the age of 50 have a trust, but in many, many cases, those trusts are not funded. Not funded or not notarized, or basically they're just a pile of paper that are worthless when it comes time to use them because they didn't do them correctly. So why don't more people have an estate plan? And the reality is that they think it's an intimidating process. They think it's going to be very expensive. It's going to cost a lot of attorney fees. It's an uncomfortable topic. Nobody wants to talk about their death because, after all, we're going to live forever, aren't we? They think it's also very complicated. This is going to take up too much of my time, etc. So the reality here is that when it comes to estate planning, you either have a plan or the government has a plan for you. So either way, there's a plan. The question is, do you want to control your plan or do you want to have someone else control your plan for you? Your first choice would be to ask these questions. Who makes the decisions over your assets, your health care, your family's future, etc.? You or the government? And how much of your estate do you want to be paid to the courts and to the lawyers? Now, I got a lot of great lawyer jokes if you want to talk about that when the time comes. And I want to remind you that at no point here today am I providing you with legal advice. I'm not a lawyer, and I'm not going to provide you with legal advice. I'm going to tell you how the game is played and what the rules of the game are so you can decide how you want to play the game. So if you have no estate plan, then that is a guaranteed ticket to probate. And probate is a legal process by which they verify your will. And if you don't have a will, they assign you a will. And it's quite expensive, as you'll see. The courts decide who receives your assets. Your private matters are public record. Now, this is pretty important because what happens here is that once this becomes public, all the vultures come out of the woodwork and start looking to prey on you as far as what your assets are and how to get their hands on some of those assets in some fashion or form. And that's just not fun. And your family waits for months before receiving the assets. So the average probate can take up to 12 months or longer. It's somewhere between 12 and 24 months on an average probate. Multiple probates, if the assets are in 2 or more states, if you own a piece of real estate in, say, California and one in Arizona, and you don't have your trust in place, then you're going to be going through probate in both states. They cost thousands of dollars in cost and fees. And this is money that you could be passing on to your heirs rather than giving it to lawyers, the legal system, and the government. Cost of probate filing fees alone in the state of California are $395 and $400 in Florida and $223 to $300 in the state of Idaho. And each state's a little bit different. You can certainly look to see what it is, but I would tell you that the easiest way to do this is just avoid those costs by being sure you have your legal documents in place. You have to file legal notice fees, bond fees, personal representative fees, attorney's fees, and appraisal fees, and the hits just keep on coming. The average cost of a probate, somewhere between 1% and 8% of your gross estate. $300,000 estate would cost you somewhere between $3,000 and $24,000 in needless money going out the door just because you didn't take the time to plan. And you could hear me say this over and over and over again, and that is people don't plan to fail, they fail to plan. California, it's $100,000 estate could cost you $8,000 or more just on the fees that you're going to pay going through probate. Under some state laws, the attorney and personal representatives are entitled to reasonable compensation. The typical average probate is between $2,000 and $5,000 plus time, 6 months to over a year, plus the loss of privacy, which I think is probably the most important thing, because remember, the vultures come out of the woodwork. We already have to deal with in-laws and outlaws, and if we don't have an estate plan in place, that even becomes worse. So what are the benefits of avoiding probate? So for sure, we're going to save some money. Number two, we're going to save some time, and you've heard the saying that time is money. We'll save a lot of stress and paperwork, and we'll maintain privacy for our family. Our family's already going through a very tough time. They don't need that to become a public event. So how do trusts eliminate probate court? Well, living trust is a contract. It's created in a separate entity that will outlive you and eliminate the need for courts. A revocable trust is a legal document that creates a new entity, funds your assets into that trust. You own and control the trust while you're alive. You move those assets out of your trust, in or out of your trust. They specify what happens to your assets after you die. And it's revocable and changeable, which means that you can change it at any time because you are in control of your trust right up until the day that you die or you become incapacitated and you can no longer make decisions for yourself. You decide, not the court, who receives your hard-earned assets, when they receive them, and at what age. And you can also stagger that, maybe give them some at 30, some at 35, some at 40, whatever way you want to do it. How they receive them over time, lump sums, etc. Who makes the decisions if you're incapacitated and now you don't have some person that you have no idea who you are or what your life's all about making it if you didn't take the time to do that. Who manages your assets for minors? This is especially important in a special needs trust. And who raises your children? Are your children going to go award to the state, or have you already assigned somebody to be their guardian should you pass away? A comprehensive estate plan includes a revocable living trust, a last will and testament, or what would be called a pour-over will, a durable power of attorney, and your advanced medical directives. These are all documents that everybody should have inside of their estate plan to make sure that they're covered and their family's covered going forward. A last will and testament is often called a pour-over will. It's used in conjunction with a revocable living trust to convey anything you've forgotten to fund into the trust prior to your death, hence pour-over. So if it was left outside of the trust, after your death, it can be moved into your trust so it can be distributed in accordance with your wishes. Any unfunded assets will go through probate first unless they are minimal value. And that varies state to state. Powers of attorneys, the two main durable power of attorneys for finance and healthcare. Durable means that the appointment of the power will endure even after your incapacitation. The power is effective either upon the date of your execution of the documents or upon your incapacitation, depending on the selection you make in the document. You're in control. The durable power of attorney for finance will give your appointed agent the power to make basic financial decisions regarding assets not funded into your trust. For assets already funded into your trust, the trustee already has that authority. Your agent may use the power to buy and sell non-trust assets, write checks from your non-trust accounts. He or she could even fund assets into your trust prior to your death to avoid probate. The durable power of attorney for healthcare allows your appointed agent to make important healthcare decisions for you in the event of your incapacitation. But choose carefully, because your agent can terminate your life support system even if the principal is not terminally ill. So you want to be careful about who's making those decisions. You might not want to put your ex-spouse who doesn't like you much. Living will and advance directives. Well, living will and advance directives are allow you to determine how you want medical care administered if you have a terminal illness or if you are comatose state. If such a condition should happen to you, these instruments will serve to give notice to the medical professionals your wishes. How about a last will and testament? Well, that's a great question. See, people say often, well, I have a will. It's much better than nothing, but it's a wish document, and it passes through a government probate. We always say that a will is a guaranteed ticket to probate, because remember, probate verifies your will, and if you don't have one, it provides you with one. So what's the solution here? Well, the solution is an internet-based estate planning technology. EP Documents is that technology. It's a very simple process. You go step by step on an online platform, walks you through the process, and online videos and printed guides will help you all along the way. In addition to that, when you're working with us, you will have your own concierge who will help you to make sure that you get this all done correctly, quickly, funded, and notarized to make sure that everything is in place and you can sleep at night with comfort. It secures your documents in a vault and stores signed copies of all your documents 24/7 access. And one of the greatest things about this service is for the rest of your life, you will be able to make changes to this trust at any time without paying any further expenses, other than whatever it would cost to notarize it. It's a simple online process that walks you through. You can create documents in about an hour, maybe a little bit longer depending upon how many heirs you have and what your assets are, but it takes about an hour to get all of this process done. So what about special needs trust? Well, this is a very important question because we may have somebody that's a spendthrift or drug addict or possibly a Down syndrome child or whatever the case may be that is going to need a special needs trust to get them through the process. Special needs provisions included in all trust. The language to create a special needs subtrust is included in every plan. Just click the disabled beneficiary will be included in the special needs subtrust. Caring for special needs is what matters. Successor trustees will make sure the child is cared for, providing health, maintenance, education, and support. They live off the trust that you set up. Special needs beneficiaries are protected. Beneficiaries will never receive a lump sum. They will receive an income only from the trust. so government benefits will not be jeopardized. Online funding. It's a patent pending system to track assets and funding for the clients. This funds everything. As you can see here, there's many things on this list. Our life insurance, our casualties, our cars, our cash accounts. In addition to that, our cars, our boats, our RVs, and much more. Our retirement accounts, etc. Now, when you're walking through this process, we're going to help you to understand which one of these assets you would put in your trust and which ones you wouldn't, because some of these assets don't belong in a trust, and as long as they have a beneficiary form trumps all, and we do have a pretty good plan just using the beneficiary form. But we're also going to make sure that we have a beneficiary form on everything, and it's either got a primary and a contingent beneficiary on it, of which possibility is that's going to go into the trust. It's professional and it gives you a complete peace of mind. So to get this trust, you merely have to go here and scan this code or call this phone number and set up a no cost, no obligation appointment, and we'll help you to figure out how this is going to work for you. It's very inexpensive. It's much less expensive than any other trust lawyers out there in most cases. And it's a one-time cost, and you can make unlimited changes to it over time with no additional cost other than what it would cost you to notarize it. So remember, live like you're going to die tomorrow and plan like you're going to live forever, because you just might. Feel free to reach out to us at any time. Keep smiling and be sure to get your planning done today. Don't be one of those people who procrastinate. I know. You're going to live forever. Well, my suggestion to you is that doesn't always work out that way. So be sure to get this done soon. Keep smiling. Make it a great day. Hope to talk to you soon. Bye-bye now.